Welcome back, everybody, to our studies in land law. The previous lesson we talked about the express granting of an easement, the expressed acquisition of an easement more specifically. And we talked about how this could be done through either grant or reservation, specifically talking about the process by which a vendor may be inclined to, upon the conveyance of their property, they may be inclined to essentially withhold access to potential areas of their property or potential rights over that property by way of an easement, and this is sometimes known as an expressed reservation. We also noted in the previous lesson that there were three main ways by which an easement is acquired. Well, technically four if we include statute, but we're not going to be talking about statute very much, given that it's very, very simple. A law is passed that gives grant to an easement, simply put. The three main ways in which an easement is acquired in the law is through expressed acquisition, implied acquisition, and this process known as prescription. This lesson is going to focus on the second of these ways of managing an easement and acquiring an easement, namely through the implied grant of an easement. The previous lesson, as I mentioned, was a relatively straightforward process, the process of express acquisition of an easement in land law. This lesson shall look at the implied grant of an easement in land law, a topic which has a little bit more complexity attached to it. Hence, the length of this lesson is slightly more so than that of the previous one. So, an implied grant of an easement, as the name suggests, is a situation where there is no expressed contingent in place for the acquisition, the granting, or the reservation of an easement, but rather the courts have been able to, for a particular reason, imply that an easement has been granted, either through necessity, either through the concept of common intention, or through the rule in Weldon and Burrows, the case from 1879, and or finally under the provision of Section 62 of the Law of Property Act. So if there is a situation which arises in which the courts feel that it is pertinent to imply the granting of an easement either through one of these four methods, then an easement will have existed and have been acquired by this implied grant. Let's begin then with the first of these processes, the concept of necessity in the applying or the implying of the granting of an easement. Well, essentially, an easement can be implied through a court over a piece of land if it is determined that in order for the use of that land to actually be able to be done, it is necessary for there to exist an easement. This is fundamentally what the process of necessity requires. That if it is implied, essentially, if we look at a piece of property, we look at some land, and we think, well, you cannot enjoy or use this land without the grant of an easement. It is necessary for the enjoyment of that land and the use of that land. So the courts have set a relatively high bar, a relatively high standard for what is required in relation to the concept of necessity here. It is more than just the desirable element of the land. It is more than just, oh, I would enjoy this land more if there was an easement. It has to be the case that it is necessary for the use of the land. So, for example, if the land in question was locked off without the existence of some right of way, then it must be necessarily the case that an easement is implied, if it isn't expressly stated in the grant already, over another piece of land that essentially gives you access to your land. That's more than just the mere desirability of the property. That is essentially strikes at the heart of being able to even use that property in the first place. Hence why that would be considered an implied granting of an easement by way of necessity. The case of Minjiang versus Dramar from 1990, for example, held that an easement may not necessarily be implied Under this method, under the method of, for example, locking some property out and blocking a right of way, if there is another route to the property. And this is the case even if this other route is less convenient. And that goes back to the second point that I have cited on this slide here, the sense that it must be more than just merely desirable and a merely desirable element on the property. It has to be more than that in order for it to actually be a necessity for there to be a grant of easement. If there's another way of getting to that property, even if it is less convenient, if it is a bit more cumbersome, this would still not satisfy the necessity requirement for the implied grant of an easement. Easements implied by necessity are not implied for convenience or desire, but like I said here, they are implied for the necessity of the use of that property. Secondly then, common intention, the second of the major elements that we would refer to here. Well, an easement may be implied through this idea of common intention if it is necessary for the use of the land for a specific purpose for which there is a common intention among the parties, among all the parties to this particular property. If there is a common intention among all of them about what this property ought to be used for, then this common intention requirement would essentially imply the granting of an easement. As one would argue, something of a variation of an easement which is implied through necessity, there is still a certain element of necessity required in this common intention requirement, but more specifically we're talking about the common intention by the parties. The previous implication is done on the basis that any use of the land must require an easement. This is done on the basis that the intended specific use of the land requires an easement. So, whereas the implying of an easement through necessity required there to be an easement for any use of the land at all, and I used the example of some property that essentially is blocked off by some other property, such that there is no way of even getting to the property without going over or going across that property. But this is slightly different. This isn't necessarily talking about any use of the land at all. It is suggesting that there may be an agreed upon, a collective agreement on what this land is going to be used for, but that in order to even use that land for the property that is going to be used for, there is a necessity of having some kind of easement. That's what that requirement essentially relates to. And I want to draw your attention to the 1965 case of Wong and Bont Property Trust Limited. This was a case in which a landlord had leased his property to the tenant for the purposes of running a restaurant. So there is a specific purpose for this property. It is the property of a restaurant business. In order to run the restaurant, the tenants would have to comply with a myriad of different health and safety standards, of course, one of which would require the fixing of the various different ventilation systems on the property to ensure that they were up to the standard of health and safety at the time. Now, an easement was therefore impliedly granted in the lease in order for the tenant to fix the ventilation system. Notice here that what this does is illustrate the view that when the landlord leases this property to the tenant, there is the common intention. There is a mutual intention on the part of the landlord and the tenant to have this property leased for the purposes of setting up a restaurant. And this is a very specific purpose. And in order to set up a restaurant, you must therefore comply with health and safety standards. And in order to comply with health and safety standards, there must be the fixing of the ventilation systems on the property. And so if there wasn't this common intention, if the landlord had simply leased the property for living in that property potentially, then it might have been the case that there would not have been the necessity for the easement of the fixing of the ventilation system, because the fixing of the ventilation system had to be done in order to comply with health and safety standards for a restaurant business. And so as a result of all of this, it is suggested here that it is necessary for the running of and for the use of the land in the way that it has been agreed upon that that land is going to be used, that there was an easement in place in the lease, implied in the lease by the court, for the fixing of the ventilation systems. The third way in which a lease, an easement can be implied into a lease, into a property at all, really, not just a lease, is through the case of Wealden and Burrows from 1879. This case establishes a separate rule for the creation of an easement, which may be implied by a grant of something known as a quasi-easement. The case itself involved a dispute between a claimant and a defendant who had both been sold land by a third party. This third party we'll just call A. To the claimant, some of the land was sold, and to the defendant, a month later, a workshop which was adjacent to the land was sold. Now, the claimant would build a board, which would ultimately lead to the blocking of light entering into the workshop of the defendant, at which point the defendant would, quite rudely in my opinion, knock it down, claiming that it had access, that they had access to light by way of an easement. Now, I'm not sure if there was a conversation prior to this about whether or not they could take the board down amicably, but all that we know is that the defendant knocked the board down. If you want to read the facts of the case, you can go and do so. But they argued on the basis of this that there was access to light that was implied through their easement. And it was argued that when the seller of the property sold the land to the claimant, he had impliedly reserved the easement access of light. There's access to light easement. The courts actually disagreed with that, and they found for the claimant, and they concluded that the defendant did not in fact have access to the light by way of an easement. But what this did was establish a rule. The rule has the effect of taking a quasi-easement. So this is a right which is for the benefit of your own land, and then elevating that to a full easement. And the courts concluded in this case that there were three conditions that are required for the creation of this type of easement. The quasi-easement must be firstly continuous and apparent. Secondly, it must be necessary for the enjoyment of the property for which it was sold. And then thirdly, it must have been enjoyed by the vendor before the sale of the property, when they were the owner of both the dominant and the servient tenements, the dominant and servient properties. If you have those three conditions, then you may have the possibility of implying the granting of an easement through the Wealden and Burrows case and the Wealden and Burrows rule. Finally then, let's get to Section 62 of the Law of Property Act, the final way in which we can imply an easement through the courts. Essentially what this does is allow for the passing of all rights which exist over a land, including the easements, to a successor without the need for this to be an expressed implication in a conveyance. So essentially, if you buy a property and own a property, and you have an easement on that property, and there's no controversy about how this easement was acquired, it was maybe even that was expressed in the deeds, and you go about enjoying the property, and then you go on to sell that property. Well, to suggest here is what we are thinking about is that Section 62 is essentially saying that you can then pass all of the rights which existed over the land that you enjoyed, and this includes easements, and this can be done without there being an express note in some kind of conveyance agreement saying that there is an easement, okay? And I would just like to finally finish this lesson by talking about the case of Wright and Macadam from 1949. This was a case which involved a landlord who was the defendant, who had had let a top floor flat to the claimant. In this agreement, they gave the claimant access to their garden, specifically their garden shed, for some storage purposes. An additional room was then granted to the claimant in a new tenancy for her and her daughter to live. Change in circumstances, now they wanted to essentially create a new tenancy agreement in which she would get an additional room. This new document, however, made no reference to the enjoyment of the shed for storage purposes. So it was an easement that she had enjoyed as expressly stated in the first tenancy agreement, but there was no such reference to it in the second tenancy agreement. This might have been just something of an oversight as to everything that is included in both agreements. When the defendant then attempted to extract payment for the use of the shed, the claimant argued that their new tenancy agreement included a right to use the shed, just as the previous tenancy agreement had as well. This went to court, and the court indeed found for the claimant, and they held that in accordance with Section 2 of the 62, of the Law of Property Act from 1925, there is the ability for the license for storage to be converted into an easement granted impliedly over that property.